but do not go to the prison and become institutionalized where you think that's the place to be. You can go there, you can get your GED, you can get a college degree. I need a PSI date for this, please. Okay. Oh, he is?
Yes.
Okay, well, somebody stamped it as though he was not set today. Okay. Oh, no problem. All right, court is calling 2023 CR 8695, State of Texas versus Paul Anthony Pettis. Could I have parties announced for the record for the state? Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
And are you Mr. Pettis?
Yes, Your Honor.
All right, you entered a plea of no contest on October 24th, 2000.
This is one of the most intense cases we've seen in a while. A young man, just 18 years old, facing charges for aggravated assault with a deadly weapon. The victim? Stabbed so deeply it punctured a lung. And yet, what unfolds in this courtroom isn't just a story about violence. It's a story of desperation, mental health, and a plea for redemption. Defense argues he was barely an adult, living in a chaotic group home, under financial stress, grappling with substance abuse. But does that justify what happened next? The prosecution isn't buying it, and neither is the judge. What really happened that day? Where did the weapon come from? And will this teen's remorse be enough to avoid a full sentence? Stay with us, because the judge's final words may surprise you.
23 to the offense of aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application, and there's to be restitution. Have both parties had a chance to review the PSI report, state?
No, I haven't. I was unaware that Mr. Sandoval was here.
Okay, no problem. I think we only requested the TAP evaluation and criminal history.
That'll be fine.
Yes, Judge.
And so do you all have criminal history to tender to me? All right. If y'all need time to get that, I can call the next case. All right, no problem.
Your Honor, if I may, on behalf of Mr. Pettis and for efficiency purposes, Your Honor, although PSI was not done, the TAP evaluation was done, and there was a notation on there about him being slightly motivated for treatment. And in my discussions with Paul over the last 6 months, shortly after him just turning 18, being arrested for this, he's well aware that his future is at a crossroads, that his entire life is at a crossroads, and that the activity with respect to substance abuse and his experimenting with that needs to change. That was not in and of itself the reason for what gave rise to this incident. Through no fault of his own, financial hardships led his family to living in a, for lack of a better term, a group home, which was a highly stressful situation. Mr. Pettis has reflected upon all this. As I said, he had just turned 18 upon his arrest. He's been in custody for 6 months, will not turn 19 for another 6 months.
So counsel, let's just wait until the state is ready to give me the criminal history.
Well, okay. Well, I was just informing the court with respect to the slightly motivated portion of the TAP evaluation. Oftentimes it comes across as the lack of motivation, where what's really intended is he doesn't want to be a problem to anyone.
All right.
Judge, a motion. PCIC.
Thank you. Any objections to the court reviewing the?
No, Your Honor. In fact, we appreciate it and
Just judicial dialogue, Your Honor.
All right, thank you.
That's as an adult, and then PS and previous juvenile.
All right, counsel, you may continue.
And Your Honor, Mr. Pettis presents himself, and I say Mr., it really should be, as I said, it should be Master Pettis, presents himself seeking a chance from this court as an adult under the criminal justice system. He has not had an opportunity to prove himself, not to the court or to the state or to myself, but to himself and what he can accomplish, especially.
This is where the courtroom takes a dramatic emotional turn. The defense paints a picture of Paul Pettis as a young man caught in the crosshairs of a harsh life, financial hardship, instability, and early exposure to substance use. Just months into adulthood, he's already been behind bars for 6 months. His lawyer doesn't just defend him, he pleads with the court to see him as someone on the brink of change. But here's where we pause and ask, is a person's environment enough to excuse violent behavior? Should youth and hardship factor into punishment for a crime that nearly killed someone? Let us know in the comments. Would you give him probation or prison?
Given the sword of Damocles which hangs over his head, should he fall short, if this court, in its ultimate wisdom, were to allow him community supervision and the opportunity to turn his life around. I was taken by the court's attention paid to another young man earlier today. As odd as this will sound, Your Honor, it may sound odd to everyone in this courtroom, but what I wouldn't give as a 58-year-old male to be in Mr. Pettis's position right now, even though he's in an orange jumpsuit and in handcuffs. He's 18 years old. He has his whole future ahead of him. And what I wouldn't give to be 18 again. And if he only knew now what I know and what we the judge is far away from my advanced years, but what we now know. And it's given the totality of the circumstances of this young man's life. Society would not be harmed given the localized tension that gave rise to this event and him being given an opportunity. And if that opportunity also includes, we've discussed, Mr. Pettis and I, the necessity of some sort of substance abuse treatment, even inpatient, to begin the process to allow him to, again, not prove himself to this court or myself or Judge Garahan or anyone else, but to himself that this is not him. And it does not have to be him, nor does it need to define him. And Mr. Pettis presents himself to this court. Should the court have any inquiry, or should Judge Garahan have any inquiry of him?
All right. State, you're silent on the application, but according to the plea, it's a cap of 6 years.
It's a cap of 6 years silent.
Oh, and you're silent on the cap as well?
Yeah, yes.
Okay. All right. Has anyone had any contact with the complainant?
He had some previous contact, Your Honor. They're aware of the.
All right. Anything you wish to say, Mr. Pettis?
I just want to say that I know what I did was wrong, and I'm very sorry.
So can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Paul Pettis.
All right, so what were you two arguing about?
We weren't arguing about nothing. I literally just got out the shower and he attacked me.
That's not what it says in the stipulations.
That's what it should say.
That's not what it says. Do you want a jury trial?
No, I don't.
All right, so according to the stipulations, it doesn't say you were outside and he attacked you. So you say you just got out of the shower and that's when he attacked you. I need you to say yes or no.
Yes, Your Honor.
All right. So you just get out of the shower, and I'm assuming you're nude because I don't know anybody who showers with their clothes on normally. So you were showering with no clothes on. Am I to assume that?
Yes, ma'am.
All right. So immediately upon getting out of the shower, did you have a chance to grab a towel or anything of that nature?
Yes, ma'am.
All right. So you grab a towel. Did you have a chance to wipe off with the towel, or did you just have it wrapped around your body?
I had a chance to dry myself.
So you dried yourself. Did you have a chance to put on clothing?
Yes, Your Honor.
So you put on your clothes. So when you say he immediately attacked you after you got out of the shower, did this happen in the bathroom or where the shower is or no?
And I got out the restroom.
All right. So you're in the restroom and immediately when you walk out the
This part of the testimony gets downright confusing and critical. Pettis claims he was attacked right out of the shower, but the judge quickly exposes inconsistencies. He had time to dry off, get dressed, and walk out of the bathroom. So, where exactly did the stabbing occur? And was it really in self-defense? Then comes the twist. It might not have been a knife, it could have been scissors. But either way, someone got stabbed, and the judge is clearly not impressed by the shifting details. Remember, this is more than just storytelling. These inconsistencies could mean the difference between leniency and hard time. Would you believe his version of events?
restroom door, that's when you're saying he attacks you?
Yes, he said, "What's up, local?" And I said, "What's up?" And then I turned around and Rudy had his shirt off and attacked me.
So, had you stepped out of the bathroom when he attacked you?
Yes, I did.
All right. So, I'm assuming that your bathroom does not have knives. Did you have a knife in your pants?
I did not.
All right. So, where does the knife come in? Because he got stabbed.
I'm not sure.
Well, I mean, it says you had a knife. So, from the time you're saying he attacked you in the bathroom, you dry out, you come out, there are no knives in the bathroom. So, where did you get the knife?
I don't think it was a knife. I think it was scissors.
All right. Okay. Is there anything else?
Your Honor, on behalf of Mr. Pettis, again, this living arrangement judge, due to the financial circumstances his family was going through, was very tension filled. Whole bunch of folks living in and it's no excuse. As he said, he apologizes for his action. And listening to the court's dialogue with Mr. Pettis, for clarification purposes, I want to stress that Mr. Pettis is relaying these facts to a court with an 18-year-old's mindset in not seeking justification, Judge, but just seeking some path to the best outcome possible. And no deception. And this is from my 6 months of working with Mr. Pettis and having visits with him. He's always come across as very articulate, very polite, very courteous, and has helped me in structuring possible defenses. As the court may be aware, there was a time where Mr. Pettis came forth and explored the possibility of maybe seeking other counsel, and we worked through that. And so he's maturing. And I believe that given the opportunity, that path of maturation can continue.
All right, Mr. Pettis, I want to let you know that I listened to everything you said. I always reread everything and look at everything, and I'm taking in consideration your age. But according to the police report that I reviewed, the complainant got stabbed and it went through his lungs. Could have died, right?
Yes, sir.
So I'm not going to grant your application. I'm going to find you guilty, but taking in consideration your age, I am going to sentence you to 4 years in the prison. The state will add a cap of 6 years. Give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Omar Morales Sastre, S-A-S-T-R-E. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel, if you think it's appropriate, I'll request for him to be placed in the therapeutic community to address any mental health issues, if he has any, or drug issues.
Your Honor, any courtesies that could be extended by this court and its wisdom would be appreciated.
All right. And Mr. Pettis, you'll need to request the therapeutic community as well for them to even consider it. You understand?
Yes, Your Honor.
All right. We can go off the record. I realize that you're very young. I realize that going to prison or either going to the Bexar County Jail, any time that you do where you're not free is a lot of time, even 24 hours. But do not go to the prison and become institutionalized where you think that's the place to be. You can go there, you can get your GED, you can get a college degree, and they do not charge you for it. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Okay,
Thank you, Your Honor. And for the record, he does get credit for all the time he served.
Yes.
Thank you, Judge.
In the end, the judge strikes a careful balance, acknowledging Paul Pettis's age and potential, but not ignoring the gravity of the crime. Despite a plea for leniency and no prior adult convictions, the court imposes a 4-year prison sentence under a plea cap of 6 years, with a deadly weapon finding that will stay on his record. The judge even offers Pettis a path forward, recommending therapeutic community placement and encouraging him to earn a GED or college degree behind bars. A stern reminder, prison is not meant to define your future, but how you respond to it just might. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. New cases, real drama, and legal insights every week.